Update to a story that outraged students and parents, not just here locally, but across the country. You may remember in 2018, some high schoolers at Niagara Wheatfield walked out of class furious over how the school district handled the situation around a rape case. A male student who was accused of sexually assaulting a female student off school grounds was still allowed to attend school and play sports. It made national headlines, and last year, New York State's Attorney General stepped in and sued the school district, saying that it ignored student concerns and failed to protect them. It was the first time the state had filed this type of lawsuit against a school district. Well, now we've learned that a federal judge has dismissed that suit. This was first reported today by the Buffalo News. The judge found that the AG just didn't have standing to file that claim. Paul Cambria is a criminal defense attorney with Lipsitz Green Chimay Cambria here in Buffalo, a 2 on Your Side legal analyst, and he joins me now live. Paul, always great to have you on the show. Can you explain to us why the judge dismissed this case? And we hear this concept of standing, right? Standing. This wasn't so much on the merits of the case, right? It was just whether or not the AG is in a position to be able to file something like this.
That's correct. In every federal case, you need to have so-called standing. Standing means a sufficient connection to the case to allow you to be a party. Here, what happens is there's a concept called parens patriae. And basically what that is it allows the government to stand in the shoes of parents, if you will, for children, but only under certain circumstances. And what happened in this case is that Judge Sinatra, in dismissing the lawsuit, said there wasn't standing, a sufficient connection, and under the parens patriae doctrine, that means that there has to be an allegation that the Attorney General has stepped in because there is a sufficiently significant or substantial segment of the community that is affected by the alleged action in the lawsuit. So here, what the court said is we had 4 students involved. That does not rise to the level of a substantial segment of New York's population. And so therefore that doctrine of parens patriae cannot be invoked by the state. Now that doesn't mean that the individual students and through their parents can't sue. It means that the Attorney General can't do it on their behalf. And so he dismissed it as a result of that. Some of the times we see let's give you an example of a real parens patriae case that would not get dismissed if somebody was polluting a children's swimming pool at a school or something like that. It would affect a lot of people, a substantial part of the population. So we see it in that fumes, sewage, things like that are easy examples. There are a lot of others.
So, Paul, I'm almost out of time, but so what are the bigger implications of this? I mean, is it just that the judge here was kind of applying a standard that we already knew before, or does this mean that we can expect the AG wouldn't take on cases like this in the future?
Well, this is a well-established standard across the nation. It's been expanded from time to time, but basically it says these are 4 cases that maybe were stitched together to try to establish the substantial segment, but the court does not find a substantial segment. Again, it doesn't say that the people don't have a remedy. They can sue privately, but this is the Attorney General doing it for them. This case didn't have enough of an impact, according to the judge, to allow parens patriae standing.
It's still such an interesting case. I mean, we covered this so much back when it happened and all the outrage in that community, and this just the latest development. Paul Cambria, attorney here in Buffalo and a friend of the show. Paul, great to see you as always. Thanks for your time.
Pleasure.